The title of my revised essay is Apprendi to Rights. The Sixth Amendment states, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury." I've been thinking about when the criminal prosecution ends. Does it end when the court accepts the jury's verdict or the defendant's plea of guilty? Maybe not. Maybe the criminal prosecution continues until the court pronounces sentence and enters judgment, or maybe even longer. Might the criminal prosecution around which the Sixth Amendment is built continue even after sentence and judgment? The Supreme Court grappled with these questions in a little notice case decided in the final days of the October term 2018. In United States versus Hammond, the defendant was convicted of possessing child pornography, a crime carrying a maximum of 10 years in prison. Pursuant to a provision of the Adam Walsh Child Protection Act of 2006, he also faced an enhanced term of supervised release between 5 years and life. Hammond was a first-time offender. The judge sentenced him to 38 months in prison and 10 years of supervised release. While Hammond was under supervision, a search of his digital devices turned up images of child pornography. There followed a hearing on the probation officer's allegation of 5 supervision violations, including possessing more than 60 images of child pornography. Using the preponderance standard mandated by federal law, the judge found that Hammond knowingly possessed 13 images and revoked his release. Had the usual statute governing supervised release revocations applied, the judge said he, quote, probably would have sentenced in the range of 2 years or less. But under a further provision of the 2006 Adam Walsh Act, the judge, having revoked his release, was required to sentence Hammond to an additional term of imprisonment between 5 years and life. While the sentencing judge found this provision repugnant, he sentenced Hammond to the mandatory minimum additional 5 years in prison. The 10th Circuit reversed, holding the mandatory term unconstitutional under Aileen versus United States, where the court had applied Apprendi's requirements to increases in the minimum as well as the maximum of the lawful sentencing range. On June 26, 2019, the Supreme Court affirmed the 10th Circuit. Hammond, like all the other decisions in the Apprendi line, fractured the court. 3 justices joined Justice Gorsuch's plurality opinion, and 3 justices joined Justice Alito's dissent. Justice Breyer concurred only in the result. These 3 opinions warrant careful attention because they raise important questions about why Apprendi treated 2 discrete constitutional requirements, proof beyond a reasonable doubt and the right to jury trial, as though they were one. According to Justice Gorsuch's opinion for the plurality that included Justices Ginsburg, Sotomayor, and Kagan, Apprendi and Aileen together teach that the defendant has a right to have a jury determine whether the government has met its proof beyond a reasonable doubt as to any fact that increases sentence, lawful sentence. Hammond was sentenced to 5 additional years of imprisonment on the basis of fact-finding by a judge, not a jury, even though both that judge and the 10th Circuit found that the government had barely met the preponderance standard as to his knowing possession of the child pornography. Inconveniently for Justice Gorsuch, the additional 5-year sentence was imposed in a revocation proceeding that took place years after Hammond's original sentencing. Justice Gorsuch reasoned that Hammond's sentence was not yet final for Apprendi and Aileen purposes until the judge imposed that additional sentence. This plurality opinion brushed past the court's well-established holdings that other aspects of the Sixth Amendment, such as an unqualified right to counsel, do not apply to probation or parole revocations. It's not clear whether Justice Gorsuch paused to consider the possibly profound implications of his argument for the whole panoply of Sixth Amendment rights: right to jury trial, right to counsel, right to confrontation. Focusing solely on Apprendi's twin constitutional requirements, the plurality asserted that the government could not trump these rights by simply delaying the proof of certain sentencing-enhancing facts far beyond the completion of the defendant's sentencing proceeding. Answering the question that I posed at the outset, when does a criminal prosecution end? Justice Gorsuch wrote that criminal prosecution continues until a final sentence is imposed, which includes any supervised release sentence a defendant may receive. And he pronounced the foundational principle that he thought Apprendi stands for. Quote, any accusation triggering a new and additional punishment must be proven to the satisfaction of a jury beyond a reasonable doubt. If this broad dicta were to be accepted by a majority of the court, that is, if the entire Apprendi line of cases were transplanted to post-sentencing proceedings, our present understandings of probation, parole, suspended sentences, and supervised release would be thrown to the wind. Indeed, Justice Gorsuch appeared to throw down this very gauntlet in his portentous opening line. Only a jury acting on proof beyond a reasonable doubt may take a person's liberty, end quote. As Justice Alito's powerful dissent, joined by the Chief and Justices Thomas and Kavanaugh, as he pointed out, taking a person's liberty is exactly what revocation of probation, parole, or supervised release does. To understand the radical nature of Justice Gorsuch's approach, realize that he says only a jury may do this. This would mean that there is a right to jury trial for every probation or parole revocation. Because of what Justice Breyer politely called the, quote, potentially destabilizing consequences of Gorsuch's opinion, he declined to join it and expressed agreement with much of the dissent. Although Justice Breyer provided a fifth vote in Hayman's favor, he did so on the narrowest of grounds. He noted that the court had always proceeded on the understanding that sanctions following supervision revocation are, quote, not for the particular conduct triggering the revocation, as if that conduct were being sentenced as a new federal crime, but rather are an additional sentence for the underlying crime of conviction. That is right, as all 9 justices seem to agree in Hayman. Justice Breyer might have pointed out that if revocation sanctions were punishment for the revocation conduct, that conduct could not be separately pursued in a new prosecution without violating double jeopardy protections. But the Adam Walsh provision, Justice Breyer said, is different. The requirement of a new prison sentence of at least 5 years more closely resembles the punishment of a new criminal offense. And under the Constitution, the government may not prosecute a new criminal offense without providing for jury trial and proof beyond a reasonable doubt. Therefore, Breyer concluded Hayman's mandatory new 5-year sentence was unconstitutional. Although Justice Breyer's opinion is short, even cryptic, it does succinctly capture why the Apprendi line of cases cannot apply broadly to all these revocation proceedings. So before moving on to Justice Alito's dissent, I will pause here to explicate more than Justice Breyer did, how his understanding of Apprendi and Aileen would play out in the situation of revocation that do not, in his words, closely resemble the punishment of a new criminal offense. If we understand revocation sanctions to be part of the punishment for the original crime, and again, that's the long-held understanding, the severity of those sanctions is constitutionally limited by the severity of the original crime. Here, Hayman's child pornography conviction exposed him to a maximum term of 10 years imprisonment and 5 years to life of supervised relief. So the highest term of imprisonment that Hayman could constitutionally receive on the revocation of his supervised release was the maximum provided in the statute of conviction, 10 years, minus the 3 years and 2 months to which he was originally sentenced and had served. This comes out to 6 years and 10 months. But wait, Hayman's new sentence was only 5 years, which is less than what would be constitutionally permitted. because even after adding the new sentence to the original one, the total is less than the maximum authorized for the offense of which he was convicted. Sure, the Walsh Act permitted the judge in his discretion to impose up to a life sentence, but the judge didn't exercise that discretion. So why was Hayman's final sentence of 98 months unconstitutional, where the crime of conviction permitted up to 120 months? Presumably because the mandatory 5-year minimum imposed in the revocation hearing retroactively increased the minimum of the lawful sentencing range that Hayman ultimately faced, which is barred by a lien, said Justice Pryor. Was the majority in Hayman right, at least as to the narrow understanding of its holding, that imposition of an additional mandatory term of imprisonment upon supervision revocation based on new judicial fact-finding violates a lien? Justice Alito and the three joining him didn't think so. He did a fine job of highlighting the potentially far-reaching consequences of Gorsuch's dicta, which indicate that any fact-finding that leads a judge to impose an additional deprivation of liberty upon revocation of supervision is unconstitutional, whether or not it involves triggering a mandatory minimum or altering the maximum sentence. Justice Alito was also, in my view, both careful and convincing in his interpretation of the Sixth Amendment, which is that it doesn't speak to supervision revocations at all. The question I put to you at the outset, when does the criminal prosecution referenced in the Sixth Amendment end, is actually more complicated than my question implies. That is because some Sixth Amendment rights are of longer duration than others. A supervision violation proceeding certainly happens after the defendant's speedy trial right has come to an end. Last year, the court made it clear that the speedy trial clause doesn't even apply to the sentencing proceeding. Moreover, as Justice Alito points out, the Sixth Amendment says that an accused enjoys the right to jury trial. And once the verdict or guilty plea is entered, the defendant is no longer accused of being guilty. He has been found guilty. Likewise, it seems to me the revocation hearing is clearly after the criminal prosecution has ended, even as other constitutional protections do apply. Take, for instance, the right to counsel. That right features prominently in the Sixth Amendment, but the conditional right to counsel at certain parole revocation hearings recognized in the Gagnon versus Scarpelli decision in 1973 was not about the Sixth Amendment right to counsel. It was about a right to counsel as a component of the Constitution's insistence on due process law. Gagnon was a 14th Amendment due process case, just like the right to counsel pointedly mentioned in Miranda warnings. And due process is what I want to end with. We do well to remember that the Apprendi line of cases connects two different constitutional rights, the right to trial by jury and the right to proof beyond a reasonable doubt, as recognized in In re Winship. It's time that we decouple these rights. They are different. The latter requirement, proof beyond a reasonable doubt, is not a Sixth Amendment right. It is a due process right. And I don't mean the Sixth Amendment as incorporated through the 14th Amendment. I mean the standalone due process clauses of the 14th and 5th Amendments. It seems to me that the Hayman case was a missed opportunity for the court to disentangle the two Apprendi rights. Hayman's revocation and new sentence did not violate or touch upon his right to jury trial in a criminal prosecution because the criminal prosecution was over. But the district court was compelled by the Walsh Act to sentence him to an additional 5 years in prison, at least, upon finding to a bare preponderance that recently Hayman knowingly possessed 13 images of child pornography. Why isn't that a violation, though, of In re Winship? Winship itself was, like Hayman's revocation hearing, a proceeding in which there was no Sixth Amendment right to jury trial. Criminal contempt is another example of a proceeding that does not require a jury trial, but does require proof beyond a reasonable doubt. I urge that we should consider whether revocation proceedings are more like juvenile proceedings and criminal contempt than they are like, say, bail hearings. I urge you also to look again at Justice Stevens' dissenting opinion in McMillan versus Pennsylvania. That 1986 dissent about the legislative specification of a factor that, if found by the judge, required imposition of a mandatory minimum sentence, was, in my view, the first in the Apprendi line of opinions. Justice Stevens said that when the legislature finds a sentencing factor that raises the lawful minimum sentence, proof beyond a reasonable doubt is required. His opinion was all about due process. He barely mentioned the jury, and only in footnotes, and didn't make a big deal about it. To be sure, judicial fact-finding and criminal sentencing may also involve denial of the defendant's jury trial right, as Apprendi held. But the jury trial became an almost excessive preoccupation of Justice Scalia, whereas Justice Stevens in the 1990 cases leading up to Apprendi and in Apprendi itself gave greater attention to Winship's requirement of proof beyond a reasonable doubt. Justice Gorsuch's apparently even greater preoccupation with juries is unfortunate. For all 9 members of the court, Hayman was about the limits on the right to trial by jury. Too bad. We don't often have jury trials in the United States, not anymore. But we have many final proceedings beyond the occasional criminal trial in which the government seeks to prove facts that will require or authorize significant infringement of someone's liberty. Civil though some of these proceedings may be, we need to honestly decide whether due process of law requires that in such cases, the government truly be put to its proof beyond a reasonable doubt.